Most employees don't realize that they actually have some rights. It's true that if the general rule is you're employed at will, you can be terminated for any reason, but there's an exception. The law provides exceptions. One of the big exceptions is Title VII. You may not be terminated because of your race, sex, national origin, religion. And of course, they've added age and disability. There are many whistleblower laws that protect employees from standing up for violations of the law, including discrimination. Some of the challenges that you should be aware of when you take on a case, and fundamentally, how do you prove your case? Because most of the time, discrimination goes on in the shadows. No one's going to say, we're getting rid of you because we want someone 20 years younger. We don't want you because you're black and you do not fit in. No one's going to say that. So how do you prove it? Well, you can prove it circumstantially. You can prove that if you were otherwise qualified for your job and you're replaced with someone outside of that protected class, and the reason that the employer gives for your termination is not believable, then the law provides that you have proven that circumstantially. That a jury may find that because they believe that it's more likely that you were terminated for something that was not what the employer said, they may infer that it was discrimination.
In this insider-exclusive investigative network TV show, our news team goes behind the headlines in Independent Contractors and Employees' Rights, Tewonna Williams' story, to examine how Brian Sanford, founder of the Sanford Law Firm, successfully got justice for his client, Tewonna Williams, in a lawsuit against the Veterans Administration on the very important issue of workers' rights and the common misconception by employers about who really is an independent contractor and who is an employee. It's important for employers to correctly classify their workers because that classification determines whether or not the employer has legal obligations under the law for unemployment insurance, workers' compensation, wage payments, work hours, record keeping, and civil rights protections. Moreover, hiring firms need not provide independent contractors with benefits ordinarily provided to employees such as health insurance or vacations. There are consequences for misclassifying or attempting to misclassify a worker as an independent contractor. Misclassified independent contractors have to pay all their Social Security and Medicare taxes out of their own pocket, are ineligible for unemployment benefits, and their employer won't have to pay for unemployment insurance for them, are ineligible for workers' compensation benefits, and their employer won't have to pay for workers' comp insurance for them, do not have workplace rights that employees usually have, such as a right to a minimum wage, overtime pay, sick pay, and rest breaks, are ineligible for health care coverage as an employee under Obamacare starting in 2014. Employers can save a lot of money by classifying workers as independent contractors instead of employees. That's why many of them do so, even if the workers involved should really be treated as employees under the law. If you think you should be treated as an employee but have been classified as an independent contractor by your employer, there are lots of things you can do, and they can often be very effective. First, talk to your employer. Try to talk to your employer to see if it will review your classification and reclassify you as an employee. Explain that you think you've been wrongly classified as an independent contractor. At the very least, you should get an explanation as to why they think you are a contractor instead of an employee. Get the IRS involved. If trying to talk to your employer doesn't work, you can contact the IRS. Workers who believe they have been misclassified as independent contractors may request that the IRS determine their employment status for federal tax purposes by filing IRS Form SS-8. There's no fee for filing. If the IRS or other government agency determines that a hiring firm has misclassified an employee as an independent contractor, it can order the firm to treat the worker as an employee and require it to pay back taxes and substantial penalties. The IRS uses their IRS independent contractor test to determine whether a worker is an independent contractor or an employee. And in this insider exclusive special, Brian will explain some of their more important criteria. Brian Sanford has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Dallas, in Texas, and across the nation. His goals, not only to get justice for his clients, but to make sure that everyone is treated with equal respect and dignity as guaranteed under the Constitution of the United States. He has built a substantial reputation by consistently winning cases other law firms have turned down. His amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Dallas, Texas. It is my great pleasure to introduce Brian Sanford to the show. Welcome to the show.
Thank you, Steve.
I understand you're an employment lawyer. That's what you primarily do, right?
Yes.
There are many types of practices of law that a lawyer can practice. They can be personal injury, they can handle medical malpractice cases, but you stick with employment law. Why is that?
Because I feel like I can make a difference. You're not going to get rich practicing employment law, not usually, but you get to act as a private attorney general to pursue laws that help protect the community and make it a better place.
Mm-hmm. You know, when we were flying here from Los Angeles, one of our staff brought up the issue that many companies in California, which is an employee-friendly state, are now migrating to states like Texas, which is not so employee-friendly.
Probably the opposite. Probably the least employee-friendly.
Why is that? I mean, it benefits businesses, but in what ways is it least friendly to employees?
Because you have some of the least rights here in Texas. At will is strongly enforced, at least in the federal courthouses.
Yeah.
And we don't have other laws that other states have. For instance, we don't have a common law whistleblower protection here in Texas.
For our audience, and they've seen this time and time again, at will means your contract, your employment can be terminated any time for at will.
Any reason, good reason, bad reason, no reason at all, without any notice.
Okay, except
when
a law is violated.
That's right.
Correct.
You have to find an exception.
Yeah, and that's where you enter the picture.
That's right.
And today we are here talking about one of your clients, Tewonna Williams?
Yes.
Am I saying that right? Tewonna?
You're right. Tewonna Williams.
Okay. Who was an employee of a staffing agency that had a contract with the Veterans Administration.
That's right.
The federal government. And tell our audience a little bit about Tewonna and what happened.
Well, Tewonna is a great person. She's very determined, very good employee. The employer, even the VA said best employee in that group. She is also nobody's fool and will stand up to anything that's wrong.
She's a pharmacy tech,
She was a pharmacy tech.
Yeah. And so what happened to her at work? She's working at the VA and...
Well, she's working at the VA, and her supervisor is actually someone that's an employee with the VA who begins to want to, he begins to sexually harass her.
Yeah, and what would he do?
Well, he asked her, basically propositioned her.
Yeah.
And she said no, and she tape recorded him. And then
she did tape record him?
She did.
How did she tape, on her cell phone?
She just brought in a tape recorder and put it in her purse.
Okay, and are you allowed to say what he said? Because you went to trial on this. This is public knowledge.
We went to trial. It was public knowledge. I can't remember. It's been a while since we had the trial, but basically he admitted to propositioning her in a previous conversation.
Yeah, and he said basically, I'm going to paraphrase, if you have sex with me, I'll get you promoted, I'll get you the ideal job.
That's right.
And she turned him down, right?
She turned him down.
What happened next?
Well, then she filed an EEOC charge.
But before she filed the EEOC charge, didn't he put her in a lesser position?
He did.
Yeah.
When he turned her down, he not only didn't give her the promotion, but he then took away her current position and transferred her back to the place she had started out at.
Which, in the eyes of the law, is retaliation, right?
It is.
He broke the law by sexually harassing her.
That's right.
Intimidating her, because that's a better term, I think. Then he retaliated against her because she wouldn't do what he wanted, what the master wanted, right?
Yes.
And what happened after that?
Well, that's when she filed her EEOC charge.
Yeah.
And within just a few days of filing the EEOC charge, the employment agency terminates her.
Yeah. So behind the scenes, most probably, the employer, the VA, that supervisor, made a call to the staffing agency. Hey, one of your people caused me a lot of problems. Drummed up some, fictitious baloney, and she's out. She's out of work now, right?
She's out of work, but of course, the employment agency wasn't the one that made the decision. As you imply, it was the VA that actually made the decision.
Yeah.
But they're trying to be shielded from that by saying, we're not the employer.
Yeah.
It was the agency that terminated you.
Yeah. What did the EEOC come back and say?
The EEOC did not come back. The EEOC said, you were not the employee of the VA, so we can't help you.
Okay. So somebody fired her, but if she's working, and this is what this whole story is all about, whether you're an independent contractor or whether you're an employee, correct?
Yes.
Somebody fired, nobody's taking blame for it. The temp staffing agency is not taking blame. The VA is saying, hey, we can't fire her, she was never an employee, correct? And the EEOC doesn't see through that, catch-22, right?
They do not.
She's out of work, she has no job, she's fired, but nobody fired her, right? And the EEOC can't take a position here, can they?
That's right. So the employment agency says, nothing we can do, we can't find another position for you, sorry. This is a big problem, really, in America.
But tell us what happened to this in the case first.
Well, so we filed a lawsuit against both.
Against the VA and the staffing agency.
Right.
I think it was top echelon contract.
That's right.
Okay.
So we resolved our differences with top echelon and moved forward with the VA.
Yeah. Here's my question. Top echelon resolved it quickly, didn't they?
They did.
Why?
Well, I think they knew what the problem was, and in fact, one of their managers all but admitted that there had been retaliation.
And there had
by
to be,
the VA.
Yeah, but there had to be some communication between the VA and top echelon, correct?
Yes.
Like a phone call.
Yes.
You got a troublemaker.
We don't
want her here.
There was an EEOC charge filed. A few days later, the VA says, you need to let her go. Top echelon says, you can't do that within a few days of the EEOC charge.
Yeah. So you sue the VA.
Yes.
Who represents the VA?
The assistant U.S. attorney.
So
the U.S. attorney's office.
Okay. So here we have tax dollars at work, right?
Yes.
We have the full weight and measure of the United States government with unlimited budget.
Yes.
Fighting a law firm like yourself.
Yes.
Okay. Who's saying, the VA saying, we're not the employer, right?
That's right. So it's me, one individual, at the trial against two assistant U.S. attorneys.
Fighting the United States government.
Fighting the United States government.
Yeah.
But again, on my side, I'm like the government. I'm a private attorney general.
Yeah.
The law actually says that.
Yeah.
So yes, so we're going against the government, and we have the government says, look, Tewonna signed an agreement, says she's not the VA employee.
Yeah.
The VA and the employment agency signed an agreement that says Tewonna's not the employee. So
Here's the
on
evidence.
paper, here's the evidence. And their whole argument to the jury was not the employer.
Yeah. Now, this brings up the judge's instructions and the law and what determines what is an independent contractor and what is an employee. It isn't just a document that says, I'm not an employee of your company. What other factors figure in that determination, which is what the jury clearly understood and came back in favor of Tewonna was? What are those other criteria?
So the other criteria that you have is you really look at what is what is really the truth?
Yeah.
The core is who controlled the details of the work.
Yes.
So where did you go to work? Did you go to work at top echelon's place of business or at the VA? Who provided you the materials? What desk? Did you have tools? Did you have, whose work were you working on?
Yeah.
Who controlled the hours?
Yeah.
Are you just working on a project? Or are you required to come in at a certain time and leave at a certain time? Who is supervising you? Is it the agency's employees that are supervising you? Or is it the so-called contractor that's supervising you?
Yeah.
So it doesn't matter what the agreement says. You and I could sign an agreement that says we're sisters. That doesn't make us sisters.
Yeah.
It's what is the reality.
Okay. And that's, that's the reason we're doing this show, because oftentimes somebody might be terminated, right? And I'm sure in the beginning, Tewonna talked to her family, her friends, and they said, wow, you are SOL. You're out of luck, right? You sign this document, you sign that document, they're going to win. And what makes me angry is the fact that the United States government uses the entire budget of the United States, the U.S. Attorney's Office, to continue to represent this morally and illegal action by the VA, correct?
Yes.
Because there are other factors. If you gain nothing else from this show, it is that there are a multiple number of factors to determine whether you really are an independent contractor or an employee, and it doesn't matter what you signed, right?
That's right.
So why do businesses like to classify people or misclassify people as independent contractors rather than employees?
Two big reasons. Cheaper, don't pay them the same benefits as their other employees. Second, they can hide behind that relationship to avoid accountability for violating laws.
Mm-hmm. There's a lot of, like Microsoft is a company, a lot of Fortune 500 companies that have employees, that have nice benefits, have stock options and all this other kind of stuff, but they also have a lot of contracting companies like from India and various other places. How do they beat or get around these issues about coming to the same place of work every day, reporting at a certain time to, like for example, Microsoft's campus, using the computer and equipment that Microsoft purchased, following certain breaks and hourly. How do they get around that? Because in essence, what I'm seeing is they might be employees too. How do they get around it?
Well, it's difficult for them to get around it.
Yeah.
So it all comes down to who controls the details of the work. The more it's project oriented.
Yeah.
Look, I need this result. I'm going to pay you so much money. You come back with the product or that service. You're an independent contractor. But if I'm guiding you every day through and telling you how to do your job, then you're an employee.
Mm-hmm. So I guess the contractor would say, here's your contract. Don't talk to the on-premises supervisor. Call us if you have any questions.
You have a plumber come into your house. You say, look, I'm going to pay you $1,000 to fix my bathroom. You're not telling him how to do it. That's an independent contractor.
Yeah.
You bring him in and you provide the tools and you tell him how to do the job. You tell him what time he's got to come in, and when he leaves, he's an employee.
So the good news is you won the case.
Yes.
Okay. And Tewonna is gainfully employed some other place, correct?
Yes.
Okay. It's still kind of a stigma against her record for suing somebody, which she had to do. Nobody likes to be in these positions, do they?
They do not.
I would venture to say that every client that comes in your office that you eventually take on as a client never has been in court before, really doesn't want to be in court, do they?
That's really true.
And they like to settle things amicably, because I keep bringing up the United States government, the U.S. Attorney's Office. That's pretty awesome, isn't it?
It is. It's a very fearful thing to go against the United States.
Now, how you get a lot of people call your office, and I'm sure you will after the airing of this show, that think that they have maybe have been misclassified as independent contractors. How are you going to choose the cases and the clients? I'm just curious about that.
Well, we do get a lot of phone calls, so we look to see if there is a remedy for the situation. Is there a law that's going to provide something that we can start with? We're willing to advance the law, but there has to be some type of law that protects you. And so like in the independent or versus the employer context, we're going to look at the factors that you bring in. And if it looks like it's close to a situation where you're being treated and misclassified, we want to talk to you, and we want to interview you, and then we'll make a selection after we've done the interview.
By the way, online, I think anybody can go and they can find, I think the IRS used to have a 20-point schedule. It's now been reduced to 11 points that anybody can read to determine for yourself whether, and here's an even funnier situation. You have the IRS, which is the federal government. You have the U.S. Attorney's Office, which is the federal government, and one doesn't look at the other's guidelines.
They do not. Well,
I mean, this is ridiculous.
Well,
and who pays for this?
Because there's
taxpayer.
There's actually different laws. So when you ask if somebody's an employee, it depends on who's asking.
Yeah.
So if it's the IRS asking about your tax return, there's one set of law that defines what an employee is. If you're asking in terms of discrimination or retaliation, the Title VII defines an employee under a different definition.
Yeah.
If you have a whistleblower statute, it's going to define an employee. Each one of them is a little bit different, but fundamentally it really does come down to who controls the details of the job.
Good, good. Well, congratulations on winning the case, and I want to thank you for sharing this case. This is a big case. Thank you.
Thanks, Steve.
You're welcome. Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.